Good morning.
Morning, Judge.
Morning, Your Honor.
Morning.
All right, let me go through Lone Star Title versus Juan Manuel Duran.
Andrew Davis on behalf of Mark Davis, representing plaintiff, Your Honor.
Okay. And it's a default hearing, meaning you filed the lawsuit and no answer's been filed.
That's correct, Your Honor. Your Honor, defendant was served, I have the citation right here, on August 6, 2025.
Mm-hmm.
No answer was filed. In our motion for default judgment, we include the plaintiff's certificate of last known mailing address of the defendant, a non-military affidavit, and our affidavit in support of attorney's fees.
Okay, give me the nature of the contract.
My client is a local closing company. The defendant was the seller. He neglected to mention outstanding ad valorem taxes. The sale went through, and now there's a tax problem on the back end. The default.
Hold on. Are you talking about real estate?
Yes, that's where it started.
Okay. And how much are you asking for in your lawsuit?
Uh, a judgment of 11,800 for the taxes and attorney's fees totaling to $17,276.31.
17,000 in attorney's fees.
No, Your Honor, 5,000 in attorney's fees. The taxes were just under 12,000.
All right, I'm gonna have to. I've got a whole full docket here, and I try and do these Zooms for the open and shut kind of routine stuff. But I think for 5,000 in attorney's fees, I'm gonna have to have a hearing in person. So you can just set it with Robert, and Robert set this in an afternoon where I don't have any hearings after that. Okay.
Yeah, it sounds good, Your Honor.
All right. Thank you. Let me get next. Brittany Rodriguez versus EPT Sand Pebble Apartments. Mark Williams and Ashley Cedillo, lawyers. Nobody here? Okay, not here. Felix Torres versus Albert Flores, Veronica Rivera, and Foy YL Development, real property. Scheduling conference, Mark Davis, and then defense, Lane Reedman. Are the lawyers here?
Andrew Davis on behalf of plaintiff, Your Honor.
I'm sorry. I got a whole array of faces, and I didn't see which lips moved. Who just announced ready?
Andrew Davis on behalf of plaintiff, Your Honor.
Thank you. Okay.
And Carlos Quinones on behalf of the defendant, Your Honor, Mr. Albert Flores.
Okay. And then I have here a note that you're looking for a bench trial.
Yes, Judge. Well, I filed a motion for summary judgment on behalf of the defense. We need a hearing set, Judge, in person.
Okay. Well, we'll give you the in-person, and I had here a scheduling conference, but Robert, I don't mind if they just want to do the bench trial. I can schedule that, and then if some other complication comes up, I can always reset that. Have you all gone to mediation?
We have not, Your Honor.
No?
I just got into the case, Your Honor. I don't think I haven't. I don't know if they have before.
Well, Mr. Davis says no. I prefer that you go to mediation first.
We have no objections to that, Your Honor. I would note that this case is originally filed in 2022. I'm pretty eager to get a conclusion here. I don't think the final will be a very long one.
Well, wait a minute. I asked about mediation. Is your response about the mediation, or are you telling me about the nature of the case?
No, I was
I'm asking, have you been to mediation? I heard no. So I'd like for you all to go to
I'm
mediation. Do you have a mediator that
understood, Your
you can
Honor.
agree on, or is there a reason why this is not a mediationable case?
I can't point to a reason it's not a mediatable case, Your Honor. I just think it's been pending a long time. You know, the parties are.
Mr. Davis, if you want to go into that, we
No,
can. I mean,
I,
when have you said it? How many times have you said it? And what did you do to get it set to go to trial? Have you filed for a jury trial? I understand what a 2022 case means, that it got filed in 2022.
yeah,
Okay?
yes, Your Honor, and I'm not opposing mediation. I just
Okay. No, I know. You're just making other comments and I'm responding to them. All right. So, how much is in controversy? A ballpark figure is fine.
It's their petition, Judge. Mr. Davis?
I think he's trying to figure out.
Oh.
Ballpark figure is fine. Mr. Schwartz, I'll take you after this, okay?
Yes, sir. Thank you.
Which one is your case?
2025 DCV 3065.
Okay, I'll come back to you all with a name of a mediator. If you can
Thank
figure
you.
out how much is in controversy, that would help me as to who I appoint. Okay, River Oaks.
Yes, sir.
Landlord
Stuart
tenant.
Schwartz on behalf of River Oaks Properties Limited. We're here on a motion for default judgment against Fernando Muniz and Cool Joe Cuts LLC.
Mhm.
This is for a lease of space at 3260 North Saragossa Road, Suite B202. I've supplied the court with an affidavit in support of the motion, as well as an affidavit for attorney's fees. The balance on the lease after efforts to mitigate damages is $53,968.85, and we're asking for $4,000 in attorney's fees.
Okay, the default here, it's a default, meaning they never filed an answer.
Correct.
Was it personal service or 106?
This was a substitute service in accordance with the court's order by email,
Okay.
received on November 11th.
Oh, okay. So you verified that it got received?
Yes, sir. And the returns are on file as of November 12th. September 12th.
Okay, thank you.
September 11th and September 12th.
All right, it's almost a year. No, November 11th. We're not even there yet.
No, September 11th and
Oh,
September
I'm sorry.
12th.
Okay.
No, I misspoke. It was my fault.
Okay. Yeah, go ahead and submit your paperwork, and if it doesn't get signed by next week, don't be shy about calling up and following.
That's fine, Judge. We did have forwarded it to Mr. Vasquez.
Thank you very much.
Thank you, Judge.
Your excuse.
Yep. Thank you. Bye-bye.
Bye. Okay, let me get back to the Felix Torres. How much is in controversy?
we're really seeking to clear title on that, Your Honor, but it's 20,000 down payment that wasn't given credit for.
You're clearing the
I'm
title.
sorry, 15,000 down payment that wasn't given credit for.
Okay. Give me 1 second. I'll be right back. Okay, I'm going to ask you to please go to Carlos Cardenas as a mediator. and try and get it. It's already going to be November. I don't want to, bog you down unless you tell me that you both insist on going. But if you can do it by the end of January, and then you wanted a bench trial, and Robert, you can give them a setting anytime in February or March for a bench trial. If you manage to mediate it, and it would help me to get notice and not get ready for that bench trial. If you let me know that you managed to settle the controversy. Is that okay, Mr. Quinones?
Of course, Judge. Yes, we will.
Okay. Okay, Mr. Davis, thank you very much.
Thank you, Judge. Thank you for your time.
Robert will give you your setting. Thank you.
Thank you, Your Honor.
Yes, sir. Okay. I have here Maria Elizabeth Burciaga for the estate of Maria del Carmen Carrales versus Garcom Inc.
Yes, Your Honor. Jason Medina for Ms. Burciaga.
Okay.
Good morning, Your Honor. This is Dan Hernandez on behalf of Garcom Inc.
Good morning, Your Honor. Fred Hutter on behalf of third-party defendant Dantex General Contractors.
Okay. What is, well, it's a special exception hearing, so.
Your Honor, this is Jason Medina. I think there was a status conference initially set, and then the special exception were filed and were set also. I can tell you, I think as it relates to part of those special exceptions, there was an amendment filed a couple days ago, which may have resolved at least a portion of it. I think there are some issues that with the changes in the amendment, we may need to refile regarding some new defenses that were pled, for example, mitigation of damages. There was one item that was not, essentially the wording was changed, but no facts were pled regarding I guess mitigation was added, and then but we can probably forego that, try to resolve that based on the new amendment, and then if we need to have it heard again, do that, Your Honor, to save some of the court's time today.
So the special exception had been set, and then there were changes in the circumstances?
Yes, Your Honor. There was an amended answer filed on the 27th, I believe, or 28th, and a response filed the day after, which indicated that that was moot. I think there are some issues that probably weren't brought up. I know in this case, if you recall, Your Honor, this is one that's been set a couple times, and new parties were brought in. There was a motion to dismiss an architect firm, which the court ordered and granted that motion to dismiss, so they're no longer a party, but there are still pleadings related to that architect and the amended filing, so I think we need to address those separately. Which were not brought up in the initial special exceptions based on the previous order. But in all fairness, Mr. Hernandez has come in fairly recently. Carlos Rincon was representing Garcom, withdrew, and then Mr. Hernandez has come in, I think in the last month and a half or two, if I recall. Daniel, you can correct me, but fairly recently. I think the two issues on the status conference were we were set for the general contractors motion for summary judgment. It was set by Zoom, and I think we're trying to get a date for that, as well as you indicated we could get a special setting next year. And so we're looking for a trial date hearing on, I think, the general contractor's motion for summary judgment. And then to the extent we need to have a special exceptions hearing, I think we can do that at a later time if we can't get that resolved based on the amendment.
Okay, I can't tell if you were delegated as a spokesperson, but any of the lawyers here have any objections to Mr. Medina's suggestions of resetting this or not hearing it all today?
Judge, it has to be reset because plaintiffs filed an amended petition, and that's the reason we have an answer to the amended petition. So it cancels and it moots the special exceptions because they themselves amended the petition.
So I take it you don't object to what
I don't object, Your Honor.
Okay.
I'm happy.
No, well, I got that. I mean, I understand. So everybody, all the lawyers are in El Paso, right?
Your Honor, I'm in Lubbock.
Mr. Medina, you're in Lubbock. Okay.
But I can be in El Paso anytime. So.
No, I know. No. I just thought with all these little complications and then the history of already some shuffling on this case, Uh, you all haven't gone to mediation, right?
Your Honor, we mediated previously with Garcom. The architects were then dismissed, so we weren't planning to mediate with them. And then Mr. Hutter's client has not been involved in mediation, but between now and the time of any setting, we can get this case mediated. And I think can agree on a mediator. I think that was discussed even prior to Mr. Hernandez coming in. And so I think we can agree to a mediator, have a second mediation, and then I think if we can get a setting that may help us figure out as soon as we can, we'll get this case mediated.
Well, I can give you a trial setting around. I mean, just speculating with some of the stuff y'all are trying to do for the summer of 26. And if you want to shoot against that, when you say you can agree with a mediator, do you have one in mind?
Your Honor, Mitch Moss previously mediated this, and I don't know if there's.
Do you think he would have an advantage? I like Mitch as a mediator. Do you think he would have an advantage to mediate this new version of the lawsuit?
I don't have any objection to him. I think he'd be familiar with the case in some respects, which would save us all some time in trying to get him caught up. So I have no objection to Mr. Moss.
Okay, if you can mediate with him before February, and that'll give you time to do whatever continued discovery you want to do before mediation. And then Robert will give you a setting in July for a jury trial. And then before that time, if you want to set any motions for a hearing, I'll take them up.
Thank you, Your Honor.
But if you're going to file procedural motions, I would prefer not to be doing it right before trial. So get a setting from Robert if you do file motions, or there's going to be any other procedural stuff done before. Okay?
Yes, Your Honor. And I guess the last question would be getting an in-person hearing on that motion for summary judgment. I think the sooner we can do that, that may help us at mediation, depending on that ruling. But if that was the only other issue we had from the last status conference, was getting an in-person date for that.
Well, you're on the docket. You're not down for a motion for a motion for summary judgment.
Yes, Your Honor.
What was the nature of the summary judgment? Please remind me.
Your Honor, this is Fred Hutter on behalf of Dantex. The motion was filed by my client, and the general nature is Dantex contains that it has nothing to do with this accident. It wasn't in possession or control of the particular part of the premises that's at issue in this case. And so that's the gist of the motion. Dantex is trying to get dismissed from this lawsuit. If the court recalls, this was a motor vehicle accident that struck a pedestrian, resulting in her death. Garcom brought my client into this lawsuit, alleging that we were in possession and control of a sidewalk near around where this accident occurred. And so it's our contention just basically that the sidewalk has nothing to do with this accident. We don't have anything to do with the sidewalk. That's it. And I'm happy to get with Mr. Vasquez for some dates for an in-person hearing, Judge.
Yeah,
at a later time.
Right. That'll probably save a lot of time. I carried, when I was less experienced, I carried someone into the trial, and after a 2-week truck death trial, one of the parties moved to dismiss. But I don't want to do that to your client, Mr. Hutter, if that can be avoided. And
Thank you, Your Honor.
If we can at least address whether there is any liability or not. And that also will allow anybody in the lawsuit to amend in any way that you want based on whatever discovery you've had. And then and live is better since we're talking about probably a high dollar cause of action. So Robert will give you that. Robert, if you do give him a live hearing on the motion for summary judgment, if you can do it in an afternoon when I don't have any other settings afterwards. Mr. Medina, since I bet you just love coming to El Paso anytime you can, right?
I was there yesterday, Your Honor, so I enjoyed it.
Oh, well, I mean, if you have a convenient date for, that you're already going to be here or something, that's fine. Otherwise, Lubbock is close enough to where whoever wants to get the setting. If Robert will give you dates and that he'll assign the one that all of you agree to. Let me put it that way. So that's how you'll have your say. Okay.
Your Honor.
All right. Thank you. You're excused on this if you're not here for something else.
Your Honor, I have just one follow-up real quick. Is the court going to entertain a new DCO for the case?
All right. I do a lot of criminal. We don't have DCO on criminal. What's a DCO?
Oh, a docket controller. I'm sorry, Your Honor.
Well, I've usually allowed the parties to submit one. And then, I give the trial setting. And then this case is old enough now to, I don't know what kind of docket control now. I can account for all the details of how it's changed from original. So if you want to submit one, I'll be happy to, and everybody agrees to it, I'll be happy to sign it. Or
Yeah.
at the hearing, if you want to have a docket control and if you believe that you need to negotiate deadlines or whatever, I'll do that as well.
And I just say that, Judge, because under the rules, we default to a level 2, which means that the discovery period has ended. It means that all experts should have been designated by now based on the age of the case. And so that's my concern. The court, I know the court wants to move things along, and so it also sets dates for motions for summary judgment and other pleadings that need to be filed.
Yeah, I have been pretty liberal in and I've seldom had any parties assert, that the periods are over. But if it's that kind of case, well, it probably is based on the fact that let's just do a docket control hearing when I do the motion for summary judgment.
Very good, Your Honor.
That way, it'll pick up the rest of whatever it is that you need, and then Mr. Hutter might not even have to attend that. I mean, might not even be the subject of anything on the scheduling order.
Very good, Your Honor.
All right. Thank you. You're excused.
All right. Thank you, Your Honor.
Yes, sir. Next, I have Maria Elizabeth Burciaga. Well, that's it. I mean, that's the same case, I guess. 2280. Oh, that was a status hearing also. Okay. Dale Jackson and Laura Jackson versus Ana Lerma.
Good morning, Your Honor. Mario Jag on behalf of the plaintiffs.
And Your Honor, Cox on behalf of the defense.
Mr. Cox?
Yes, Your Honor.
Oh, okay. Good morning.
Good morning.
All right. Now, this is on a motion. What is it you're trying to compel?
Your Honor, we served written discovery on the plaintiff June 30th. It was due July 30th. We've never received it. I frankly thought I might get it before this hearing, but as far as I am aware, we have never received responses.
Okay, Mr. Rios, response, please.
Yes, Judge, she's absolutely right.
Yeah.
It's both, so whichever one is Judge. I just don't put both for, it's easier to put one.
All right.
But Mr. Cox is absolutely right. I've had a lot of problems getting my clients in. They have a lot of health issues aside from the injuries they sustained in this car wreck. One of my clients walks with a walker, and they've had to reschedule my meetings several times. I finally got them in to answer the interrogatories. So I will be getting them to Mr. Cox now that I have them, but he's absolutely correct. We have not submitted our discovery responses, and I won't be including any objections to them. I'm going to be answering them in full. So if he wants to circulate an order, I'm happy to approve as to form, but I'll get them to him by the end of the week.
Okay, but so everything that he was waiting for in June or July, you're saying that it just requires your effort to get a
No,
final?
Your Honor, I needed answers from my clients, and they wouldn't come into the office, or they would reschedule, or they just wouldn't pick up my phone calls. So we had a lot of problems getting them in here.
Well, I could do a live hearing, and that way they have to appear, and I can tell them.
Well,
I mean, I don't know the condition of your clients or how old they are, what the problem is, but June and July, it has been a while.
right.
And
And they've already appeared, Judge. They've already come into the office and I have all the answers that I need from them.
that's
Now
what I'm
it's
saying. So
yes.
it just requires your effort to
Now it
synthesize.
does. Yes, Your
Oh,
Honor.
okay. Mr. Cox, is that good enough for you?
Yeah, that's fine, Your Honor. I fully understand. I can't always get a hold of all my clients.
No, I know.
And either. So no, if he can get them to me in the next couple of days, that'll be perfect.
Okay. Have you all gone to mediation?
I
No,
do
Judge.
not believe we've mediated this one yet. We have done depositions. I think.
What's the amount of controversy?
Oh gosh, it's
Well,
that's kind
it's
of
a 30/60
yeah.
policy, Your Honor, and both of my clients' medicals are above 20,000.
Yeah,
So
and then because of the non-economic damage component, it's kind of an unliquidated amount at this point.
Okay. All right. Well, if you want to compel more, you can file, or
Okay.
hopefully you might even settle it.
Yeah, I think there's a good chance of that.
Yeah. Do you want me to wait before I require you to go to mediation?
Yes, Your Honor, because I think once we get these, we can schedule it pretty expeditiously and get it done.
All right. Come to the court and I'll require mediation if anybody wants it.
Okay, very good, Your Honor.
thank
Thank
you, Your
you very
Honor.
much.
Have a nice day.
You too, you're excused. All right. Eduardo Velasquez, Mr. Wenke's office.
Yes,
And I
sir.
see here Osvaldo Herrera, and then Viscount Properties, Fox Auto
And
Group.
good morning. Good morning, Your Honor. Frank Kinson with Scott Hulse for Viscount Properties.
Okay. Wrongful termination. Okay. Scheduling conference. Have you completed most of your discovery?
No, Your Honor.
No.
We've exchanged written discovery, but we haven't completed all of it, sir. And excuse me, Your Honor, and we're scheduling depositions.
Okay. Well, when's a good time? The cases from 2024. When's a good time for me to send you to mediation?
Your Honor, I would suggest maybe after the deposition. So we have a pending motion to compel arbitration, but we entered into a Rule 11 agreement with plaintiff's counsel to conduct some limited discovery. So we've set depositions for January 21st and 22nd. So, Your Honor, I'd recommend maybe we schedule another status conference after the depositions to see where the parties are at. Our hope is that we can get this resolved amicably.
Okay. Educate me, please. Either one of you. Well, Mr. Kinson. So when arbitration is at issue, how does the mediation play into that? I guess it helps before you go to the next step.
Yes, Your Honor. I guess the way we would look at it is if we felt after the depositions that we were close enough, but we couldn't get there, we could voluntarily agree to forego the expense of an arbitration just the same way we might with further litigation and try to agree upon an arbitrator who could push the parties toward a settlement. But if not, if we end up after the discovery still far apart, then I think what would happen is at the following status conference, the parties would brief their positions on the motion to compel arbitration, which, as you know, is subject to interlocutory appeal. So at this point, we're trying to avoid that whole hassle.
Right. Okay. So I can give you a jury date because this is a scheduling conference and I didn't want to continue scheduling conferences. How about if I give you a summer trial? You think that would be good enough for you to aim against, or?
Well, since Your Honor, you're also in favor of mediation, I would prefer if we could just reconvene, have a status conference to see if we need to push forward on the motion to compel arbitration.
Okay. Status conference in April or later?
That would be fine with me, Your Honor.
That
Okay,
works for plaintiff.
Robert will give you a date that will be April or later. Okay?
Thank you.
Thank you very
Thank
much.
you, Your Honor.
You're excused.